headquarters. They were asked to go over to Garners Creek and initiate a search grid using the Murray County search and rescue dogs. And in order to do so, they were to complete a lost persons questionnaire with the family members that were home. And while inside the residence, Mr. Morse and Mr. Bailey will testify that Noah, the 3-year-old at the time, walked into the room and in a spontaneous statement or question said, "Joe's dead, Joe's dead, Joe's dead." And in response to that, the Aunt Joyce, who was also present in the house, picked up Noah, sat him in her lap, and said, "Yes, baby, he's dead." This will be the testimony from 2 separate witnesses. The state is going to argue that this is an excited utterance. This was not testimonial in nature. This was not a question asked to Noah. Noah's statement was made in the course of a chain of events that would no doubt cause excitement and disturbance in the house. His brother was missing. He had been reported missing. Law enforcement had started gathering at the house that morning. People were inside the house searching. But I think the court will need to hear from both, at least Mr. Morse and then Mr. Bailey as well.
Well, I think the only way I can determine whether or not there is an applicable exception to the hearsay rule, or whether or not, obviously, if that's the statement, then the state's intent is to introduce those statements to prove the truth of the matter asserted therein, that Joe is dead, which is the gravamen of the state's case. So in order to determine whether those statements meet some exception to the hearsay rule, we're going to necessarily have to have those statements introduced. Is it possible to call the witnesses without going into all of their aspects of their testimony and limit this hearing to only those portions that are going to involve the statements made?
Yes, sir.
All right, then that's what I would request so that we can try to minimize the delay. Let's bring in your first witness.
State calls Brent Morse.
You'll come right up here. I'm going to ask you to face our clerk and let her place you under oath.
Okay. Mr. Morse, will you state your full name, please?
Brent William Morse.
And will you spell your first and last name?
Yes, BRENTMORSE.
Thank you. And Mr. Morse, where are you employed?
I work for the Tennessee Emergency Management Agency.
And what's your position there?
I'm a regional director for the Middle Region.
Thank you. Let me make sure if you'll pull that microphone a little closer to you and try to speak directly into it, then that would be helpful.
Okay.
Mr. Morse, this is a limited hearing, so I'm not going to go into all of the questions that we would ask you when the jury's in the room, but just some limited specific questions.
Okay.
Let me start with, on April the 4th of 2018, did you go inside the residence at Garners Creek, the home of Joseph and Crystal Daniels?
Yes, sir.
Was the purpose of your visit there to complete a lost person questionnaire?
It was.
And when you got inside the home and began the questionnaire, tell us what statements were made by the 3-year-old Noah, and give us a context for how that happened.
Little Noah came up to my right side and he asked the question or made the statement, "Joe dead, Joe dead, Joe dead." He said it 3 times, kind of in a loud way. And a lady to my right said, "Yes, baby, Joe dead."
And was the lady to your right Aunt Joyce?
Yes.
Okay. So just to be clear, did you say something to Noah, or did he come in and next to you on his own?
He came in on his own from behind.
Okay. Had you suggested to anybody in the house that Joe was dead?
No.
As part of the lost persons questionnaire, is one of the questions, is Joe dead?
No, sir.
So this was a spontaneous statement made by Noah?
Absolutely.
And he said it 3 times?
He did.
Joe dead, Joe dead, Joe dead?
Yes, sir.
Okay. And you're sure what Aunt Joyce said in response?
Yes, sir.
And what was that one more time?
Yes, baby, Joe dead.
Yes, baby, Joe dead.
Yes, sir.
Okay. Now, are you a law enforcement officer?
No, sir.
And your purpose for being in the house was to complete the lost person questionnaire.
Yes, sir.
In response to the report that the Daniels had made that their son was missing.
Correct.
Okay. Ask the witness.
Mr. Mitchell.
Mr. Morse, about what time did you show up at the house?
Probably sometime after 12, around 1.
And when you went into the home, how many people were in the home?
Let me count. 1, 2, myself, Mark Blackwood, the couch, the aunt, 8, 2 children, the mother, the father, myself, Director Mark Blackwood, a gentleman laying on a couch watching television, and Joyce.
Did you make a report about these statements?
Yes.
When did you turn it over?
Turned it over probably about 7 o'clock that night to the Sheriff Bledsoe.
Who all was in the room when you say Noah said these things?
Myself, Director Blackwood, Aunt Joyce, Noah, and over in front of the television, the gentleman was still sleeping on the couch, laying on the couch.
Who was?
What's that, sir?
Who was that?
I don't know. A tall, dark-haired gentleman.
Can you redirect?
No, sir.
Thank you, sir. You may step down.
Thank
Let me
you.
ask this question. Do you know what time it was, and you may have saved this, I don't know, do you remember what time it was when you got there
I'm going to say about 1 o'clock.
in the afternoon?
Yes, sir.
And were there a great number of people on the scene at that point?
There was.
A lot of activity?
There was.
All right, thank you. You may step down, I appreciate it. If you'll just remain, go back in the room they were holding you, this is not your actual testimony at this point, we're just having this hearing. So if we're going to allow this testimony, we'll call you back in, all right?
Thank you.
State may call your next witness.
State Y'all's Chad Bailey.
Ms. Fry. Come up, Mr. Bailey, if you will, please come around here, and I'm going to ask you to raise your right hand and face our clerk to be placed under oath.
Do you solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am. So help me God.
And I will ask you to speak into that microphone directly so that we can be sure to pick it up.
Good morning, Mr. Bailey.
Good morning.
Will you state your full name for the record, please?
William Chadwick Bailey.
Thank you. And will you spell your first and last name?
William, William. Last name is Bailey, Bailey.
Okay. And where are you employed?
I am currently employed with the Murray County Office of Emergency Management. I'm the Special Operations Chief.
Thank you. All right. So, Mr. Bailey, for the purposes of this hearing, we're not going to ask you questions about everything you did on April the 4th, but this is just a narrow piece of the proof, okay?
Yes, sir.
outside the presence of the jury. Were you at the Joseph and Crystal Daniels residence on April the 4th of 2018?
Yes, sir.
And you had been called there as part of the Murray County Search and Rescue Team?
Yes, sir.
Yes, sir. Why were you there?
We were requested by Tennessee Office of Emergency Management to assist in the search of a missing 5-year-old.
Okay. And did you actually go to the residence?
Yes, sir.
Okay. And did you hear, when you arrived at the residence, did you hear statements of a young boy?
Yes, sir.
Okay. What did he say?
From where I was, what I heard was a young voice ask pretty loudly, "Joe dead? Joe dead? Is Joe dead?"
Okay. And did you hear a response to his question?
I did, from a older lady, female voice. "Yes, baby, Joe dead."
Thank you. Where were you standing when you heard these statements and answer?
At that time, I was standing at the back door on the deck. It's the doorway we entered in through. My foot was in the door, and I was in between the open door and the door frame.
Okay. At that point in time, did you know who all was inside the house?
I knew of my team who was inside the house.
Okay. Who all was on your team?
Retired Director Mark Blackwood of the Office of Emergency Management. Tennessee Office of Emergency Management Agent Brent Morse.
Okay. And did you know, at that time, did you know the names of the residents that were also present?
Not at that point.
Okay. Was there a lot of emergency operations response at the scene that day when you arrived?
To clarify, from our agency or
From
multiple agencies?
Multiple agencies.
Yes, sir. There was multiple response personnel, along with private citizens, law enforcement, state agency and assets, again, and a lot of local residents just assisting.
Okay.
From what I saw.
Pass the witness.
Tyler?
You do not know the identity, or you did not, let me rephrase that. You did not, at the time that you heard these statements from the child and the older lady, you did not know who they were, did you?
No, sir.
You had no idea what connection they had to this case, did you?
Not at that time, sir.
And you do not know now whether or not they saw anything that would have led them to say those things, do you?
At this point, yes.
How do you know they saw it?
From my experience with children don't lie much.
They do repeat things other people have said, though, don't they?
They may.
So if the testimony would be at some point from this older lady and this younger boy that they were asleep in the bed at the time this happened, they wouldn't have been able to see it, would they?
I can't answer that, sir.
And again, you have no idea if they witnessed anything that day or that night previous.
At that point, no, sir.
Okay. Nothing further.
Anything further from this? All right, thank you, Mr. Bailey. We're going to ask you to step back into the room that you were previously waiting for me to make a ruling on this issue, and then we'll potentially call you back in when it's time for you to test.
Thank you, sir.
Any other proof that the state wishes to offer on this motion? No, sir. Defense have any proof they wish to offer?
No, Your Honor.
I'll hear you in argument.
Your Honor, this meets every category of an excited utterance. The state would offer two cases in support, Davis versus Washington Supreme Court of the United States and Stout versus Stout Supreme Court of Tennessee. I'll move those as not an exhibit, but it's... Judge, first of all, clearly there was an ongoing sense of urgency at this house. Everybody at the house was in an excited state. I mean, let's face it, there was a 911 call saying that the son had escaped. There was a large manhunt going on. There's a team of people inside the house completing a lost person questionnaire. I mean, this is the classic example of an ongoing emergency. Second, this is non-testimonial hearsay. This was not an interrogation by law enforcement. This was a spontaneous statement, not in response to a question of Mr. Morse or Mr. Bailey, but the child walked into the room and said, "Joe's dead, Joe's dead, Joe's dead." He wasn't answering a question. Those were spontaneous statements. And the answer was spontaneous from Miss Aunt Joyce as well. "Yes, baby, he's dead." Second, even if it were a law enforcement investigation, the case law is clear on that. Statements are non-testimonial when made in the course of a police interrogation under circumstances objectively indicating that the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. So even if this were a police interrogation, which it's not, which takes us outside the category of anything that's testimonial, it's not, but even if it were, it still is non-testimonial because this was in response to an ongoing emergency. That's the entire reason all these people were at the residence, is because the Daniels had stated there was an emergency. They called 911 because baby Joe had escaped. Excuse me,
Taylor,
Joe Clyde Daniels.
I'm sorry. Mr. Taylor, you or Mr. Mitchell wish to respond?
Your Honor, I have State versus Gilly, 297 Southwest 3rd, 739.
What's the side again? 272 what?
297 Southwest 3rd, 739. And that pretty much sets out the test for a hearsay, for the excited utterance hearsay exception.
Three-prong test.
Yes.
Three factors that have to be met.
Yes. Startling event or condition must be catalyst for the excitement. There must be a nexus between the statement and the startling event. The utterance must be forthcoming while the declarant is under the stress or excitement from the event or condition. The issue we have here is the nexus between the event and the statement. There has been no proof whatsoever that either of these individuals know whether or not these people actually saw anything. Both of these witnesses are available. Noah is available. Aunt Joycey is available. They can be cross-examined regarding their statements. Not only, and this sort of an aside, but not only do we have the issue of hearsay, we have the Crawford issue. This should not be admitted unless they testify to it themselves. The testimony, we believe, will be that Joycey and the child, Noah, were asleep in the bed when this happened, or allegedly happened. So, again, you heard no proof whatsoever that these two people know that these individuals have, and their statements have a nexus to the actual event that they would have had to have seen. I will, Judge, also cite you to State versus Land, that is 34 Southwest 3rd, 516. An excited utterance is inadmissible if the declarant lacked personal knowledge. They didn't prove that either of these individuals have personal knowledge of the events that they are talking about. There were people walking all over this place, as you heard the testimony. And This child could have heard any number of people say, well, do you think little Joe Clyde is dead? Do you think Joe Clyde's dead? Many people could have been saying that, and this child comes up and asks, is Joe Clyde dead? Because there's people talking about it all over the place. And then Miss Joyce says, yeah, I think he's dead. He's not here, I don't know. That doesn't mean they saw it. That doesn't mean they know he's dead. That doesn't mean that they saw something that would have placed them into an excited state. It means they heard somebody say, maybe he's dead. They can't prove that's not what happened. Your Honor, this is hearsay, and it should not be.
Clearly, I've had 4 cases cited to me, and in order to make a competent ruling on this, I'm going to have to take a recess and review those cases along with the rule and any other authority that I deem to be appropriate. So we will be in recess until I return with my ruling.
All rise. This court is in recess.